Welcome back. Howard University School of Law has graduated some of our region's and our country's most prominent public servants, from judges to politicians to civil rights activists. And right now, Howard Law School is preparing the next generation of lawyers at a time when the law changes quickly, even after decades of precedent. And there's some question about the legitimacy of the court. So joining me to talk about all of this is Howard Law School Dean Danielle Holley. Dean Holley, thanks so much for joining us.
Thank you for having me this afternoon.
I imagine it's quite a time to be on a law school campus. Right now, we just got a recent Gallup poll saying that the court's approval rating in the public is at 40%. Some of the justices have even come out with rare public statements about the legitimacy of the court and the integrity of the court, and they seem to disagree to some extent. But what are your thoughts about this public conversation we're having about the integrity and the legitimacy of the Supreme Court?
You know, it's one of the most difficult times in terms of the history of the Supreme Court, one of the most turbulent times. We see record low approval ratings for the court. And after the court's decision in the Dobbs case last year that overturned the almost 50-year precedent of Roe versus Wade, we see an unprecedented debate between justices, Justice Kagan and Justice Alito, openly arguing out in public about the legitimacy of the Supreme Court and the future of the court. And so this is one of the most kind of turbulent and difficult times in the history of the Supreme Court.
You have your hand on the pulse of America's next generation of lawyers. So I'm curious what it's like for young people experiencing this as they're coming of age, as they're coming to the point in their lives where they'll enter the practice of law and participate in this entire system.
You know, it is an incredibly difficult time, I think, to train lawyers. In the face of a number of things, I think, including the role that lawyers played in the aftermath of the 2020 election and in the January 6th insurrection incident, and all of the things that we've seen surrounding the controversy of the Supreme Court. So we want to instill in students that being a lawyer is a calling. It is a calling to protect democracy, and we really need to see lawyers step up and hold those values most true and publicly hold those values to protect the rule of law in our country.
A lot of things are new and different as we begin this OT 2022 term. One of them will be Justice Ketanji Brown Jackson. On Friday, we saw her formal investiture. What do you think her first year on the bench will see?
You know, so we saw the historic investiture of Justice Jackson. She obviously becomes the first Black woman to serve on the Supreme Court. After 115 justices, she's the first Black woman. So I think that's an important point of representation. People around the country want to see our country reflected on the highest court in the land. But I think what we're going to see is an even more turbulent term, maybe even than the one that we saw last year. And so her first year is likely to be a historic year, in one in which the court is really dealing with and grappling with some of the most difficult questions confronting our democracy, including issues regarding voting rights, racial gerrymandering, partisan redistricting, and also affirmative action.
Speaking of affirmative action, I would be remiss if I didn't ask you, given your scholarly expertise and knowledge here on education law and civil rights. Obviously, the court has said in the 2003 Grutter case that schools are allowed to consider race as a factor, as a part of a holistic review of the applicant. Clearly, the court has decided it wants to weigh in again here, perhaps changing the legal landscape or leaving it the same. What's your read?
You know, we've seen affirmative action go back to Bakke in the 1970s. It was reaffirmed, as you mentioned, in the Grutter case, and then again in Fisher versus Texas only a few years ago. So I think the question is, why would the Supreme Court take up what is long established precedent, like what we see from Bakke and Grutter and Fisher, on the question of race-conscious admissions? And so many people believe that they are going to use this opportunity, the University of North Carolina and Harvard cases, to overturn overturn precedent in affirmative action as they just did in the abortion cases. So I think that's what we're anticipating, is that the court will likely overturn race-conscious admissions. But we know that the plans used in UNC and Harvard were very modest plans and were approved both at the district court and the circuit court level. So they would need to overturn significant precedent to really find against UNC and Harvard in these cases. So a very, very controversial opinion that could come out in these cases. And so there's a lot of tension and anxiety around what the court will do.
Indeed, and something we'll be tracking closely here at Fox 5. Perhaps we can have you back with your expertise once we get a better idea of where the court is going on that case. Dean Holley of Howard Law, thank you so much for joining us.